Gormagat Las Cancorla. The amendment proposed by this bill and to be put to the people is one which has been a long time coming. It's particularly timely given that this year marks the 20th anniversary of Ireland's ratification of the UN Convention on the Rights of the Child. And this convention contains several principles focusing on the best interests of the child, the rights of the child to be heard, and the child's right to life, survival and development. The amendment proposed for November 10th will help ensure our Constitution helps us as a nation to live up to these noble and fundamental principles. The Constitution, as an espousal of our ideas and values, defines our nation. To a large extent, time and constructive consideration are of the utmost importance when amendments to it are at issue. No one can argue that time and careful consideration has not been given to this amendment. The debate has been ongoing for 20 years now, with contributions from legislators, legal experts, policy makers and NGOs all seeking to redress the imbalance. The Constitutional Review Group, the all-party Oireachtas committees and others have produced over a dozen reports on the matter, and I believe much of this work is reflected in the finalised proposed amendment before us. There are many reasons to support this amendment, not least because it will enshrine the independent rights of children and redress the imbalance which currently favours the rights of parents and family over children. This imbalance will be remedied as the state, through its agencies such as social workers and health practitioners, will be explicitly empowered to intervene in cases where a child's rights have been neglected or trampled on. Furthermore, the amendment will, for the first time, in the unconscionable situation whereby children have been treated differently on the basis of their parents' marital status, would also bring to an end the situation whereby some children have spent most of their childhood in foster care because of a ban on the voluntary adoption of children of married parents. This week, the Dáil debated a motion on the Magdalene Laundries, which was but one tragic and shameful chapter of our recent history. Together with the Ryan and Murphy reports into the abuse of children, either in parishes or institutions, it is beyond doubt that the rights of some children have been ignored and disregarded. This neglect went on to have profound implications and negative effects on the affected children reached adulthood. The amendment to include the new Article 42A will enable us as a society to prevent the traumatic and harrowing events of the past by ensuring state intervention to uphold and defend the welfare and safety of any child in the event of parental failure. By explicitly stating and recognising the natural rights of children, we are setting ourselves a high standard which should be common sense to any society which values, cherishes and protects its children, especially its vulnerable ones. Despite the broad support of this amendment from all political parties and most NGOs and children's charities, we would be foolish to believe that it is not without its detractors. Some have espoused genuinely held points, others have peddled complete nonsense, such as the claim that if the amendment is passed, your children can be taken off you on the basis of a phone call. Others still have castigated the amendment and view it in a similar light to the Mother and Child Scheme of some 60 years ago on the basis that it seemingly interferes in family life. Opponents in the latter category seem to have a difficulty in an Ireland which no longer imposes a morality based upon a single religion, but rather works to safeguard child welfare and vindicate the rights of children as human beings through a combination of legislation and constitutional amendments based on internationally recognised and best practice standards. This amendment should not be viewed as a standalone measure. It is the latest in a suite of measures designed to prioritise child welfare and rectify the grave mistakes of the past. Already, in the short time it has been in office, this government has reduced other significant legislative measures, including the Criminal Justice Withholding of Information on Offences Against Children and the Vulnerable Persons Bill and the National Vetting Bureau Bill. This will be joined by the Children's First Bill, which will clarify and strengthen procedures to guide those citizens working with children. These legislative bills, the wording of an amendment and the introduction of a dedicated article for children's rights to our Constitution are essential, but so too are resources. If we are to succeed in upholding the highest standard of child welfare and protection, we must also ensure that we make best use of the resources that we have.
There's 1 minute remaining.
I note and support the inclusion of the Child and Welfare Support Agency Bill on the autumn legislative programme. Recently, a task force was established to advise the Department of Children and Youth Affairs on the creation and operation of this new agency, whose sole focus will be in the delivery of family support, child welfare and protection services. I want to commend Minister Frances Fitzgerald, who is quite evidently working to reform this vital area of the government's work, as well as, of course, her work over the last 18 months in this vital area of the rights of the child. The constitutional amendment to be put before the people on November 10th is central to this work, and I would urge all citizens to support it.